Hi, folks. Hey, today's episode is sponsored in part by my favorite sponsor, SunsetLakeSebede.com. Why are they my favorite sponsor? If I had to sum it up in one word, it's because of their tinctures. Yes, I love their smokables. Yes, I love the sour gummies. Yes, I love the gummies with the melatonin. Yes, I love the fudge, although I got to lay off the fudge. But the tinctures have consistently put me to sleep now for years. They come in different strengths. They come in different flavors. Mint, citrus, original. I like the original. Sometimes I'll have the mint so it doesn't mess with my toothbrushing at the end of the evening. They also come with melatonin, like I say, in different strengths. And guess what? The tinctures are on sale right now for 35% off, both human and pet tinctures.
Whoa.
35% off all Sebede tinctures at sunsetlakesebede.com. You know this company, majority worker owned, $20 minimum wage. They grow all the hemp they use in products. They use integrated pest management, so no pesticides. Everything is third-party tested, so you know what you're getting. You can read it. It's on their website. So if you need a little help keeping a cool head or getting some sleep in these swampy days, Sunset Lake Sebede tinctures are here to help. 35%. Even tinctures for your pets. Visit sunsetlakesebede.com and for a limited time, use the coupon code TINCTURE, TINCTURE, at checkout. Deal ends Monday, July 17th. Now time for the show.
The Majority Report with Sam Seder.
The destiny of America is always safer in the hands of the people than in the conference rooms of any elite.
Sam Seder.
They are unanimous in their hate for me, and I welcome their hatred.
We must guard against the acquisition of unwarranted influence, whether sought or unsought, by the military-industrial complex.
The Majority Report with Sam Seder.
And I get the feeling you've been cheated.
It is Monday, July 10th, 2023. My name is Sam Seder. This is the 5-time award-winning Majority Report. We are broadcasting live steps from the industrially ravaged Gowanus Canal in the heartland of America, downtown Brooklyn, USA. On the program today, Mark Joseph Stern, columnist at...
Staff writer.
At Salon Slate. It's one of those days.
That was Digby.
Staff writer at Slate on the affirmative action ruling, the student debt ruling, the rollback of LGBTQ rights, and the crap show we can anticipate for next year. Also on the program today, Biden in London en route to a NATO summit in Lithuania, Turkey, saying, "Not so fast, Sweden. You may not get into NATO until we get into the EU." Meanwhile, Turkey has been sending cluster bombs to Ukraine, it turns out, for almost a year. Russia says Putin met with Prigozhin post-rebellion. I don't know what to make of that, but it seems to be news.
CYA.
House returns from recess to begin a march to a government shutdown in the fall. Senate Judiciary Committee to vote on Supreme Court's ethics bill in the wake of new Clarence Thomas scandalous revelations. Meanwhile, as top temperatures reached across the world, 100-year rainstorm yesterday hit Hudson Valley, New York, now on to Vermont. Flash flooding, taking lives of at least a couple of people. 7 Republican attorney generals have opened a probe of Target because they are carrying LGBTQ merchandise.
Okay.
Judge dismisses a lawsuit seeking reparations for the 1921 Tulsa, they call it the race massacre, but it was really a white supremacist massacre. National Labor Relations Board judge orders Starbucks to reopen its Ithaca location and rehire everybody they fired. Sixth Circuit, in a split panel, allows Tennessee to move ahead with their trans care ban for now. All this and much more on today's Majority Report. Welcome, ladies and gentlemen. Thanks for joining us. Fair warning, as I introduce my co-host, Emma Vigland, it is a balmy, 87 degrees in the studio.
Mm-hmm.
Somehow, people have been following the show for a while, know that we've had an air conditioning...
a Sisyphean sort of journey. With
saga.
Yes.
And the landlord finally got it fixed.
Yeah.
And I don't want to say finally, he's a good guy. It's just, and he bought the portable unit that I bought.
I was wondering where R2-D2
but for about 50
went.
cents on the dial, on the dollar, because I'm like, well, I don't need this thing in here. We got a brand new air conditioner. And the air conditioner apparently, it conditions the air, but it does not cool the air.
It does not. Yeah, we're in, I think, okay shape for today. But tomorrow and Wednesday, going to be in the 90s.
I'm feeling a little swampy. I'm going to fall asleep. I'm going to take a nap. I can't. In this type of weather, I can't.
I understand.
I need to be kept cool.
Yeah.
We got a lot to get to today. Let's start with this, though, because we're going to be talking about the 14th Amendment in the context of affirmative action and the sort of just bizarro world that these conservatives live in. But understand, again, this is really important. And I got into super pedantic mode with my kids when we went to Monticello about this, about a lot of things, but in particular about the idea of history, which I've learned from doing the show. I should say, that you can't, this is not, these dynamics, 200 years, 300 years in the lifespan of a dynamic like race and slavery, and this is really not as much, I think, as we think it is. And the idea that there are discrete historical eras is really just a way for us to measure time. It is not the way it works. Time is actually not a day is not 24 hours long. It is, we've imposed that.
We've
as
segmented it.
We've imposed these sort of structures as a way of telling time. But that's not the way that time works. Time just rolls on, and history is the same way. And we are in an era that is, it comes in waves. There's an ebb, and then there's a sort of and I said this the other day, the tide goes in, the tide goes out. And we are in an era where we are seeing white pushback, for lack of a better term. The power structure, one of the fundamental power structures in this country, tied in, yes, with capitalism and money, but is pushing back. The pendulum is swinging a little bit more, and it moves forward, but it does swing back and forth within the context of that. And that's what's going on here. And we have 3 survivors in their hundreds who were alive in 1921 when the Tulsa race riot, or you can call it the Black Wall Street massacre, where a district in Tulsa, Oklahoma, I think it was called Greenwood.
I'm not sure.
Greenwood district was a wealthy upper middle class a black district, and they were just basically, planes,
tens of thousands displaced, but hundreds
Greenwood.
killed. Yeah, in the Tulsa white supremacy massacre.
And this clip came from a day before yesterday, when a judge dismissed.
I think it was Saturday. So this happened Friday, And then on Saturday, the judge dismissed
the reparations suit
yeah.
by these three who, there was never any type of reparation for what took place in those days. Here it is.
Tulsa race massacre not fall under your definition of CRT?
Okay, thank you. I'm sorry, I didn't address that part. I would never tell a kid that because of your race, because of your color of your skin, or your gender, or anything like that, you are less of a person or are inherently racist. That doesn't mean you don't judge the actions of individuals. Oh, you can absolutely. Historically, you should. This was right. This was wrong. They did this for this reason. But to say it was inherent in that because of their skin is where I say that is critical race theory. You're saying that a race defines a person. I reject that. So I would say you be judgmental of the issue, of the action, of the content, of the character of the individual. Absolutely. But let's not tie it to the skin color and say that the skin color determined it.
One more follow-up. How does the Tulsa race massacre not fall under your definition of CRT?
I answered it. That's my answer. And again, I feel
the
like
Tulsa race massacre was a race massacre. How does it not fall under CRT?
I've answered your question. I do appreciate very respectful.
The 100 years of silence was about race. How does that not fall? How does that not qualify for CRT?
I appreciate your question. I'm going to give some other people some.
Yeah. Okay. I mean, this is, they don't have the ability to go into the second and third questions of this.
Mm-hmm.
They don't have the ability. I mean, the idea that, and I don't know what it is, like even he's straw manning here as to what's happening to some kid who learns about the Tulsa race massacre as a race massacre. You can't say these individuals, to say that these individuals who perpetrated this just did so because they're bad people and there was no relationship to the power structure that existed in this country. There was no relationship to the resurgence of white supremacy in the KKK. To say that there was no response by the federal government or, neighboring towns because of because of the race of the victims and because of the race of the perpetrators. To deny all that is to simply say we are going to revise the reality of history.
It's lost cause. And
it's total lost cause.
Yeah.
And we're going to ignore this. And this is just as at that time in the late teens, early 20s, we saw all these Confederate statues going up because of the resurgence of the racism that the re-empowerment, I should say, of the racism that led to the Tulsa, Oklahoma race riots. We're seeing that same sort of dynamic today.
That's a helpful lens to look at anti-CRT legislation as essentially the educational upholding of the Confederacy, and also akin to putting up those kinds of statues of Confederate generals. Like, just see it in that lens and it's much easier to understand. And just people should look up the images of these over 100-year-old survivors of the Tulsa race massacre. And I mean, let's just put this up really briefly because it just sticks out to me. And the judge who just essentially unilaterally decided that they did not have standing because the reasoning was that, you don't get to have payments provided for you for historical events that happened to you just so long ago. When I've listened to the testimony 2 years ago in front of Congress about the Tulsa race massacre by one of the people who brought the suit, I believe, Viola Fletcher. And some of the things she said and some of the things she writes about, seeing at age 7 or 8, a man's head explode like a watermelon, she described it. Hundreds of black bodies in the streets. Like, I guess if it was about the individual actions, it's just a coincidence that the hundreds dead were black and that the mob was white.
You can only be massacred as an individual.
I mean, wow, what a massive coincidence. Honestly, it's like lightning being struck 300 times in the same spot, that all of the perpetrators, essentially, a majority of them were white, and that the victims were black, and that they targeted the black neighborhood. What a coincidence.
And to be fair, there were white people dead because some black people fought back. But this was a black neighborhood. It was perpetrated by white people. And it literally, they flew planes with bombs.
Yeah.
Yeah, I mean, the 100-year-old victims, a 38-year-old, what's that guy's name? Ryan Walters, born in 1985, is going to be able to opine on this. And what the panic?
I mean, you could opine on it if you do the work of reading about it and understanding it. But the idea that somehow this is divorced from the question of race, and that by, like raising the fact that these individuals were guided by race, you have to believe that there is no concepts that exist. Like, if you don't believe that it is a legitimate characterization that white supremacy led to a race riot like this, then you can't conceive of any concept. There can't be things like freedom, or the idea that we fight for democracy, or the idea that like we celebrate liberty. Like, that means that no ideology can exist at all. No ideas that motivate people's actions. Nothing. And of course he doesn't believe that. I'm sure we could find this guy talking about Judeo-Christian values somewhere.
Right.
Or liberty or freedom. Or, there is no, if you cannot cite white supremacy as as something that motivated and motivates people at different times, then you can't cite anything.
The judge also dismissed the suit with prejudice, meaning it can't be refiled in state court. This was these people's last opportunity to kind of get some reparations for their families as they near the end of their lives.
Right. And it wasn't obviously just about...
And the city of Tulsa was the defendant, and that's who she sided with. So this is the structural racism. Yeah. The city of Tulsa is still actively trying to deny people this justice.
With regards to schools, like the panic that the right has about political activists being inserted into the school system, we should be as panicked about... That's an appropriate level of panic, but just for us and these people. Like this guy, 38 years old, he was like a superintendent or something like that.
Yeah.
But like straight out of college, just installed, and now basically as a white supremacist.
Yep.
He was polite about it. I appreciate the second question, but I'm not going to answer. We got a lot of other things to talk about. And, you'll see the same thing. I mean, Clarence Thomas of the same ideology. Like when he gets his ideological ass handed to him by KBJ in this, the same level of petulance. Now, when you have the ability to tell someone to shut up, like this guy did in that video, they're not quite as babyish about it.
Yeah.
We'll talk more about that with Mark Joseph Stern in just a moment. First, a word from our sponsor. One of the things you want to do, right? When it's this hot, your sheets become hugely important. Mm-hmm. And I was also thinking that's like, it's also time a lot of you grow up. Invest a little bit in your bedding. Because if you're like me, you keep it for 20 years. And it's true. We've teamed up with Cozy Earth. They are offering up to 40% at cozyearth.com/majority. And you enter the coupon code majority at checkout. The beauty about Cozy Earth sheets is they temperature regulate. They are made from, is it viscose?
Viscous.
Viscous? I don't know.
Think so.
I think it's viscose or something. It is, it's bamboo. They're sustainable. If you swap out your current sheets for these Cozy Earth sheets, you're going to find that, A, you have a temperature regulation. They are breathable. They are beautiful. If you do not think that you are sleeping cooler, they will refund your purchase price plus shipping, no questions asked.
Wow.
Do you have to justify it? Do you have to say I tossed and turned? No, you do not. Do you have to pay for shipping? No. You get 100 nights to try them out. So you got like the 60 nights of summer that are coming up that are going to leave you drenched in your sheets or cooler in the Cozy Earth ones. And how do they make this guarantee? Because their bedding is made from, like I say, from viscose, from bamboo. So it traps less heat. That's just the bottom line. It's been a year, maybe more. And I feel the difference. I mean, now I'm just used to it, I think.
Right.
But when I first went from like the old style sheets I had, I felt the difference immediately. And plus there's I got a whole mess of stuff from Cozy Earth now. Like my joggers.
Right.
Yes.
Yeah.
They're great. They really are great. And their customer service is great. Cozy Earth's luxury bedding and loungewear transforms lives by offering the softest, most luxurious, and responsibly sourced products in the world. That's the other thing about bamboo. So it's a weed. It's like you almost can't get rid of it. If you ever tried planted bamboo.
Invasive species.
Yes. They start with selecting only the best suppliers with an eye towards quality, responsible production, cutting-edge technology, premium materials. Like I say, you can save up to 40% on Cozy Earth. Go to cozyearth.com/majority. Enter the code majority at checkout. Save up to 40% now. Try them for 100 nights. If you have any issues whatsoever, you don't have to say what it is. If you don't sleep cooler, send them back for a full refund. That's cozyearth.com/majority. We'll put the link in the podcast and YouTube descriptions. All right, quick break. When we come back with Mark Joseph Stern. We are back. Sam Seder, Emma Vigeland on the Majority Report. It is a pleasure to welcome back Mark Joseph Stern. He's a staff writer at Slate and maybe the coiner of Opinion Palooza.
I would love to take credit for it, but it was actually foisted upon me, and I gladly embraced it.
All right,
but
well,
that
there
did
you
not
go.
originate in my brain.
Every year, the Supreme Court comes out with all its not all, but I mean the biggest cases. Their decisions are starting in like mid-June through the first week of July. Last week, and no exception. Although it seems like it's gotten later, like they're pushing it just a little bit later over the past couple of years. They like to use July 4th weekend, it seems to me, to do what Janine Garofalo and I used to call on Fridays, the silent but deadly, where they can drop this thing and it gets a little bit less attention because they know the level of the controversy. And that's the thing that I think, let's just start there, because they know. They operate with an awareness from decision to decision, from opinion to opinion, as individuals and as groups. They know what they're doing, right? Like this isn't, there's a strategy and tactics that they deploy even as they're writing opinions.
So, look, I think that's the case. The Supreme Court's official line on this is that each opinion is released as soon as it's ready. So the justices, the court says, are not timing the release of opinions to create any specific kind of narrative. They're just dropping them once they add the final period or colon or whatever. I think that's got to be fake. that's got to be untrue. I think it's very clear that these justices, and especially Chief Justice Roberts, who is the one who has most control over the timing of hand-downs, as we call them, that they are working to craft a narrative of the term and how the term winds down to a close. And this year, it was a bunch of moderate decisions earlier in June to butter people up, decisions that made people think, hey, maybe the court's not that bad. And then a slew of atrocious decisions at the very, very, very end of the term, right before the July 4th holiday, so that people would get angry and then go to their barbecues and cookouts and forget about it. And I think it's important to remember that the court has almost total discretion over its docket on both ends, right? So not only does it decide when to hand down the opinions, but it decides which cases it wants to take up. And this is something that is easy to miss when you're looking at how the court sort of crafts this story of each term. The court will take up cases like Moore v. Harper, one of the big democracy cases this term, so that it can issue a moderate opinion that will make it look more centrist and create more wiggle room for conservative opinions in other cases. So the court manipulates its docket in all kinds of ways to try to make the public like it more. And I do think that the timing of hand-downs is a big part of that.
And we should say, just to be clear here, they sit on the court for the rest of their lives if they want. And so what they're concerned about is things like legacy, things like, you know, how they're reacted to in some instances at the country club, but also the complete lack of, I mean, there is plenty of things that could be done to reform this court. We could have 13 justices on the court and maintain the traditional relationship between circuit courts and the Supreme Court justices. We could, there's legislation that's going to be introduced in the Senate Judiciary on ethics. There's a whole host of things that could be done, presumably, to influence this court. We should also say, and I just want to get this in before we get into the specific cases, is that one of the ways I've read that I think like at different times they have gotten, instead of court packing, they have enticed justices off the court by increasing their pensions. I mean, this was back in the day. And frankly, like, I'm not convinced that if I'm really interested in the Supreme Court, I know that because I've read the history of the Supreme Court. And so if I'm Harlan Crow or I'm whatever billionaire or millionaire it is, it's like, I want them to be on the court. I don't want them to leave the court. I want to make them feel like they have access to all these goodies because they're on the court, as opposed to the dynamic that existed in the past was like, get off the court, we'll give you a good pension.
Yeah. The pension play wouldn't work anymore. Presidents have also tried to appoint attorneys general who would require a justice to step out of a case. So, for instance, LBJ appointed the son of a justice as attorney general so that the justice would basically have to step down because he wouldn't be able to hear any cases. I don't think that is in the cards for Joe Biden, although Merrick Garland's daughter is a lovely attorney, and I think she'd do a great job. It seems like the workarounds have all been knocked off the table at this stage. And the pension play is clearly gone because these guys have billionaire benefactors, as you pointed out.
Right.
The only real maneuver for Congress is to exert its force as a co-equal branch of government. And we'll get into the cases, but I just want to say, I think Justice Elena Kagan is hinting at this in some of her opinions this term. And there's this extraordinary part of her dissent in the student debt case where she says, not only did the court in this case misinterpret the Constitution, the court itself violated the Constitution. And that is very unusual language for a justice to use. It is sort of saying we do not sit above the other two branches. We are part of this federal government and we have to share power. And so we ourselves can actually break the law. And I think it's kind of like a bat signal to Congress from Kagan saying, hey, look, my colleagues over here are actually breaking the law. If you want to stop it, you're going to have to step in and do something because I've done everything I can and I'm out of tricks.
Let's start with the student debt case. We had talked about it a little bit last week with the David Dayen, more about what the president could do or is attempting to do going forward to reassert this. But on that front, just I guess maybe one more like sort of 10,000 foot question. Are you, after this year, starting to see a division of labor amongst the three like sort of liberalish justices? Because it really does feel like not just in terms of like, I mean, I imagine there's like who's going to write this dissent, but like what elements each one of them, because KBJ, it seems to me, has written some of the most eloquent dissents about the Constitution that I feel like I can remember. Maybe I'm just more attuned to it now or not, and Kagan has the most institutional heft. She was a solicitor general. She was, I think a dean of a law school at one point, right? I mean, so this is someone who could bring the message of like, we need some type of reform in a way that maybe KBJ couldn't. I mean, is that happening, or am I imagining that?
I think that's a keen observation. I think also Justice Kagan likes to handle the dissents when the majority does not abide by the plain text of a law. And she likes to call out the conservatives for not actually being textualists, which is what she did in most of her student debt dissent, and what she did in the Sackett dissent, which involved gutting the EPA's protections over wetlands. And that ties into her speaking from an institutionalist perspective, because she's saying, your whole theory of textualism was that to be legitimate, a court must simply apply the words that Congress wrote. You are not doing that anymore. So how can we still have this claim to legitimacy when you are going far beyond what Congress wrote to basically implement your own agenda? I think Justice Sotomayor does more of the realpolitik stuff. She's the one who will say in her dissents, what a difference 5 years makes, because the personnel on this court has changed and we have more conservatives, and that's why these decisions are coming down this way. That's something she likes to do. It's something that I think she did in the Dobbs decision. I think her section focused a lot on how this is just because Amy Coney Barrett and Brett Kavanaugh have joined the court. So she speaks to how the political scene is influencing the decisions. And KBJ is still very new on the court, so obviously she's settling into her role. But I agree that she speaks as kind of like a counterpart to Thomas in terms of like a Black originalist who wants to use the Constitution for progressive means, who views the Reconstruction Amendments as a kind of radical proposition of equality, in stark contrast to Clarence Thomas viewing it as just this kind of wooden color blindness that does not grant any kind of powers to Congress to help remedy true racial discrimination. And I think in her affirmative action dissent especially, she was coming out swinging, saying, for 30 years, Clarence, you've been the only Black person on this court. You've been asserting a monopoly over what the Constitution says about race. And now I am finally here to contest that and to say you're wrong. And I think that is her emerging kind of position on the court, both during oral arguments and in opinions. And I think it's very powerful and a very good reason why Biden was correct to pledge that he would appoint a Black woman to that position in the first place.
And we should just say, and then we'll get to the case, the number of cases that impact our court system that deal with just with the 14th Amendment alone it's overwhelming, right? I mean, if you want to talk about constitutional cases and cases that dictate what's going on in our country, the 14th Amendment is like the sun almost in terms of the way these things revolve around it. And that is, fundamentally she's been brought in, it feels like as an expert on the 14th Amendment and for all of this pushback, because the country that we live in, when we talk about the founding fathers, we're talking about the people who drafted the 13th, 14th, and 15th Amendments, really. I mean, if you want to really talk about that. But
I think if I can just add briefly, what's interesting is that Justice Jackson's dissent in the affirmative action case cites real historians, right? Like Eric Foner, historians of Reconstruction, who are widely acknowledged to have the correct primary sources, the correct analysis, the correct expertise to explain what these amendments mean. Clarence Thomas's opinion in those affirmative action cases, they cite movement conservative lawyers who basically do law office history, as we like to call it, which is just sort of starting from the proposition that Clarence Thomas is correct and then cherry picking little bits of scraps from the historical record of the 14th Amendment to show why he was correct. And if you just look at their authorities, there's such a stark difference, because KBJ is citing the folks who really know what happened after the Civil War and what drove these amendments and their ratification. And Thomas is citing his friends, Harlan Crow's friends, people whose entire goal here is simply to shore up their ideological ambitions with some kind of phony historical argument.
Yeah, and we should be clear. Like, when you say really know what they're talking about, like, you can see their work. Like, you could, like, this is not alchemy. It's actually like people going back into the archives and realizing what was going on. And Foner, of course, was like the guy who first sort of began to sort of look at the Dunning School of Reconstruction of that whole era with some type of jaundiced eye. But let's get into the quickly the student debt. On what? Let's just reserve the standing for a minute, because this case should not have ever gone forward. But on what grounds can you look at the HEROES Act, see that the Trump administration and the Biden administration could do whatever they wanted with debt during that time, and now they can't? I mean, this is like a plain reading of the HEROES Act, it seems to me.
I agree. Justice Kagan agrees. What John Roberts says is we don't think, reading the minds of the Congress that passed this law in 2003, we don't think that those folks would have wanted the act to be used in this manner. And so we will not allow it to be used in this manner. And he zeroes in on the phrase that the Biden administration used to justify forgiving debt, which was that the Secretary of Education could waive or modify various provisions requiring the repayment of debt. And John Roberts said, yes, the secretary tried to modify debt in the same way that the French Revolution tried to modify the nobility, which is, I think, an incredibly tone-deaf comment to make when you're talking about stealing $10,000 out of millions of people's pockets. But Roberts basically said the words don't go far enough, that Congress had to say something super clear, something really, really obvious and explicit beyond waive or modify if it wanted to let the secretary forgive all of this debt. And of course, the problem with that, it comes right back to what you just said. The first administration to put a freeze on student debt repayment was not Biden's. It was Donald Trump's. It was Secretary DeVos. Her authority for doing that was the HEROES Act. And there is no way that the Congress that passed the HEROES Act of 2003 thought that it would allow a future Secretary of Education to freeze repayment of student debt indefinitely during a pandemic or anything else. They wrote the words broadly to encompass all kinds of future scenarios. They didn't think that they could game out every situation in which it would occur. So the court is put in this bizarro position where it's saying, well, Biden and Trump both did this. We think it's bad when Biden does it and not as bad when Trump does it. And I think that is pretty incoherent analysis.
But did anyone bring up the fact that Congress contemplated and, in fact, paved the way for debt relief for student debt by putting in the CARES Act, the American Rescue Act? This is the one under Biden, that any student debt relief given would not be a taxable benefit in terms of the IRS. I mean, that's like, it couldn't be any clearer that they anticipated this happening.
Right. But so the majority says none of that matters. What matters most is that Congress actually considered bills that would have erased student debt and didn't pass them. And so the majority only looks at the legislative history that helps their case. And it says, well, look, these Democrats proposed these bills that would have forgiven student debt. They didn't pass. So then Biden tried to do the same thing by executive fiat. We're not going to let him do that. And sort of erases the fact that there are all of these hints, both in the American Rescue Plan and in the CARES Act, actually. The CARES Act included a pause on student debt relief that sort of ratified what Secretary DeVos had done at the beginning of the pandemic, which was to freeze repayment. So you actually have two major laws under two different administrations that point towards sweeping powers of the Secretary of Education to either pause or cancel student debt. The majority doesn't care. And it comes in with what they call the major questions doctrine, right? And says, well, this is a major question. It involves $430 billion. If Congress wanted the Secretary of Education to answer it this way, it would have said so. And I guess, there are a lot of problems with that. One is that it doesn't actually follow the plain text of the law. The other is that every single federal action is going to involve billions of dollars. It's a big country. There's a lot of money floating around. And so by simply citing the price tag and using that as a justification to shoot it down, the Roberts Court has given itself a totally free-floating veto here to just shoot down any kind of program it doesn't like by saying it's expensive, so we're going to kill it.
But
and we should be clear. They could say we invoke this made-up doctrine if it's 5% of GDP or 4% of the budget or whatnot. They're just throwing numbers out there that are meaningless.
Well, it's what the framers intended. But like, didn't Roberts head off the Department of or the Higher Education Act in a part of his opinion? He seems to be anticipating the fact that that's going to come next, and he mentioned it. I'm forgetting the exact specifics of it, Mark.
Higher Education Act being a separate authority under which Biden could theoretically cancel debt.
Yeah. So, John Roberts does not reach out and expressly decide whether that is constitutional or legal or not, because that would be an advisory opinion, which the court is not supposed to issue, although it actually does all the time, as we'll discuss. But yeah, I think he throws cold water on the idea of that plan B by using very broad language to suggest that Congress did not give the Secretary of Education any power to cancel student debt and not tethering that to the HEROES Act. So, if he wanted to limit it to the HEROES Act, he could have just said, well, looking exclusively at this one law, we don't think it provides the hook that the administration needs. Instead, he has some very broad rhetoric saying, we just don't see how Congress gave the administration that power. Does that mean the administration shouldn't try to come back and do a plan B under the Higher Education Act? No, I think it should. I think the administration should absolutely attempt this, because this is another situation where this Department of Education has been doing this for years. It has been canceling debt under this mechanism for years, billions of dollars worth of debt, in fact. And the idea that it suddenly becomes illegal now because the Secretary of Education wants to expand the pool of beneficiaries is kind of mind-boggling. And I think it's something that the administration needs to force the court to say. Like, don't just give up because Roberts put some angry rhetoric in his opinion. Force another showdown so that the people who would benefit from your programs are understanding that you, the president, are doing everything you can to solve this problem, and it's the court that's standing in the way.
I want to come back to the major questions doctrine and the standing question, but since we're here at the Higher Education Act, the process, as I understand it, it could go one of two ways. They could just start and just say, under the auspices of the Higher Education Act, we have this authority. You people who are already in our system, 16 million people or something like that, your debt's gone, and we'll open up our website again until somebody stops us. They could do that, or they could go through this long, convoluted process, which it appears that they're doing, as a way of bringing services to the table, allowing public comment, and supposedly, and this wouldn't pay off until 2025, I guess, supposedly a way to identify potential mohelas. This is the non-plaintiff who won in this case, and thereby undercutting any type of argument for standing. What is your sense in terms of are we just where are we with the legal institutions just saying hey, this is just, they're going to come up with anything? Because for me, the major questions doctrine is Deus ex machina. They don't know what to do in the script. How are we going to get the protagonist to get across the river? I know, a helicopter shows up. I mean, that's it, basically.
I certainly agree. I think Justice Kagan and the dissenters agree. I think maybe the rosiest possibility here is that the Biden administration thinks that Alito and Thomas might leave the court in between now and when that case reaches the Supreme Court, and that they'll have a more favorable bench, which strikes me as very unlikely. But yeah, I mean, the administration is taking that longer, more laborious route that you mentioned. It's going through formal rulemaking, which is a process that's going to take probably at least 1 year. I don't think it will necessarily take until 2025. The litigation may well take until then. And I think there's a few sort of certainties that the administration has to factor in here. One, a Trump judge will immediately block 100% of what the administration is trying to do within 3 days of it happening, right? That's just guaranteed. Two, if 5 members of the Supreme Court don't like it, they will absolutely find a way to create standing out of nothing and create a reason to strike it down. And so that leads to 3, the big question mark, like how in the world do you get past those 2 hurdles? And again, I think the problem is like, you know, you're just hoping for a better court in the future. That's all that this administration can do, and show the people who would benefit from these programs that they're doing as much as they can. I know that's a really bleak answer, but like it seems
I feel like it's the first of like a series of bleak answers that you're going to be giving us today. But so, I mean, so if I hear you correctly, it's either like you have 2 options on the menu. One is to not succeed on the early side. One is to not succeed on the later side. The only value of the later side is that maybe somebody gets hit, or maybe 2 people get hit by a bus, and or that, and I'm being generous here, going through this rules process moves the needle ever so slightly in the institutional minds of institutionalists who think that they cut corners. That's why they got rejected this time around on the, I mean, like maybe there's a marginal value there.
Yeah, I think possibly. I mean, if you look at the actual text of the law, I think that the HEA is actually a stronger hook than the HEROES Act was, just because it was so easy for the court to say, oh, well, the HEROES Act was passed after 9/11. You know, this was about terrorism, not pandemics. Totally different situation. Whereas the HEA has been used over the decades to settle or compromise a huge amount of student debt, including all of the debtors from Corinthian College, which was the for-profit education chain that collapsed. And the Biden administration came in and used this power under the HEA to forgive all of that debt, basically in one fell swoop, and nobody thought it was illegal. So it's very difficult to understand how, if it's totally acceptable and fully lawful to do when there's a for-profit education chain that collapses, it's not also permissible to do in a wide range of other circumstances. Because again, until like last week, everyone had sort of thought that the power to create debt encompasses the power to cancel debt. Like that's kind of a bedrock rule. The court has pulled back on that and sort of said, well, we're going to be the policeman now. Maybe putting more formal procedures on will help John Roberts get over his toothache about this, but I'm just not optimistic.
The Deus Ex Machina doctrine. And then, all right, so let's talk about standing, because we should be talking about this both, I guess, in terms of the student debt, and it'll be a segue into 303 creative. But you said earlier, like advisory positions, the court's not supposed to do that. Will you talk about just that on a general level in terms of like advisory position? Like the difference between the court and a legislative body is that the court is supposed to resolve actual, real cases, and a legislative body is supposed to make law in terms of like hypothetical situations.
Right. So the Constitution, Article 3, gives federal courts the power to decide cases or controversies. And that means that there has to be a live controversy for the court to decide. 2 parties fighting it out, trying to figure out who wins, and the court has to have the power to give a victory to one side or the other. And this case, I mean, in my view, like this student debt case, did not have that basic bedrock requirement, because the states that were suing, none of them had any vested interest in obliterating the student debt plan. So like what the court ultimately did was say, at least Missouri has standing. And they said that's because Missouri has created this corporation called Mohila that services some student loans. and Mohila will lose money through this program, and that will take a chunk out of Missouri's a pot of money, and so Missouri has a pocketbook injury. But I mean, there's a lot of evidence that that's just not true.
Yeah, the Debt Collective did their own analysis with the prospect, right, and said they would make millions.
Exactly. And even setting that aside, the problem is that Mohila is a totally separate corporation from the state with its own power to sue and be sued. And not only did it not,
and that's according to the state court.
Yes.
That's not you saying that.
The Supreme Court of Missouri has said repeatedly that this is a separate creature under state law that is not part of the Missouri government, that has its own power to sue and be sued. And it did not want to participate in this lawsuit because it actually supported student debt relief, or at a minimum did not oppose it. It made its position clear when Missouri came in with this lawsuit. We do not want to be a part of this. And actually, it was so opposed to it that Missouri had to file public records requests to get basic information from Mohila. So Missouri is claiming to sue on behalf of an independent corporation that does not support its ultimate goals, that does not even want to turn over basic information that Missouri needs to sue on its behalf. And yet the Supreme Court still finds standing because Deus Ex Machina, John Roberts thinks there should be standing. I mean, that's basically it. This is one of the weakest standing analyses I've ever seen from the Supreme Court.
So that leads us into 303 Services, which is the story of a website maker who got a request from a guy who wanted a website to celebrate his upcoming wedding to another man. The colloquial would be a gay wedding, I guess, that he was going to have, and she said no. And I can't be, and I'm afraid if I reject this guy's request, that I'm going to get in trouble with Colorado. And so that is the basis of the case. I mean, let's get into the specifics of the case in a second. But it turns out every aspect I said following the word guy was a lie.
Yeah, that's right. None of what you just said is true. And yet it was a part of this case that has now sort of made it to the record on the Supreme Court. As the New Republic reported and other outlets have confirmed, that request was not real. The individual who submitted it was a straight man who is married to a woman. This was
who never made the submission. He never
ever made the submission. And so this whole notion that the website designer was receiving requests for gay weddings and didn't want to respond because she was afraid of getting sued, that was untrue from the start. But I will say, just to kind of take a step back, the case is even faker than that, because what you just described, that actually happened after she first filed the lawsuit. She filed the lawsuit on the grounds that could happen in the future. And she was so afraid of it happening that she needed an injunction, a pre-enforcement action from a court to guarantee that she would be able to say no in those situations. And only after she filed the lawsuit did that request come down. A cynic might say that it was created by the law firm that created this case, Alliance Defending Freedom, to try to shore up standing. There is no evidence to that theory, so I'm not going to say it's right or wrong, but something clearly very fishy happened here. I think the biggest thing that people are overlooking about this case is that when she filed the lawsuit, the Attorney General of Colorado was a Republican. And the Attorney General of Colorado at the time stipulated to everything that she needed to win her case. And by the time that office flipped into Democratic hands, the previous Republican AG had basically given this team a win, and there was very little that the Democratic AG could do to walk any of that back.
Okay, so all of the sort of factual questions about this had already been resolved, basically just signed off on by the Republican AG. And so there was no going back at that point. It's now in the pipeline with all of the factual issues having been resolved. All right, so let's grant the factual issues. Let's look at the actual case here, because it seems to me that well, I mean, you'll walk us through this, but like this opens the door to just about anything. I mean, the basic premises are, right, that she's running a business, a commerce that is in like civil society, and we have groups of people who are protected classes based upon either religion, race, sexual identity, and all that's theoretically fundamental, right?
Yes, that's all protected under Colorado's civil rights law, which is just a boring boilerplate civil rights law, basically indistinguishable from many, many others in blue states around the country, including DC and New York and California, which say if you open your doors to the public, if you participate in commerce as a kind of like public accommodation, you have to allow everyone to enter your business, or if it's virtual, you have to serve everyone without regard to their identity. You can't discriminate on the basis of any of the traits that you just mentioned. And it's important to note that doesn't mean that she had to, under Colorado's law, create a wedding website that said, I love gay marriage. And this was another problem with the Republican Attorney General stipulating something that the Democratic Attorney General tried to take back. The Democratic Attorney General said, I am the law enforcer, and I believe that under this law, this website designer could write whatever she wants on these websites. She could sell a wedding website to a gay couple that says gays will burn in hell under Leviticus. The only thing she can't do is turn away gay couples at the door. The only thing she can't do is say, I refuse your services across the board because you're gay. And the court basically rejected that interpretation of the law because the previous Republican Attorney General had read the law differently to require her to create expressive websites that specifically endorsed marriage equality. And so the court in this case draws this distinction between status and message and says that it's fine to bar a business from discriminating on the basis of status. So you can't say you're not allowed in because you're gay, but the business, if it's creating a custom product, has to be able to discriminate based on message. So it can't be forced to create a wedding website that would express support for same-sex marriage. But again, that's not what was actually going on in this case. Those are fake facts that were stipulated by a previous attorney general in order to throw this case to the anti-gay lawyers who brought it.
Okay, and so according to the court now, she can say, let's say she owns a restaurant, right? Or is that not included because it's not expressive?
So we don't know what the line here is. And that's like the big problem, one of the many big problems.
I mean, cooking is an art.
Cooking is very much an art. And I did an event with Jamel Bowie last week where he said, I'm a foodie. And when chefs create these plates and platters, like they put their heart and soul into it. This is a medium, an artistic medium that's designed to express certain ideas from the chef. And so does that mean this is an expressive message? Maybe so. And the court says that actually a business that wants to discriminate because of the message that it doesn't want to send, it can actually put a disclaimer up that says no gays allowed. So this website designer could actually put a disclaimer on her website that says, I will not serve gay couples who are getting married. And so to your example, if that chef was engaging in creative expression, they could put up a sign on the door that says no gays allowed.
All right. So we're going to humor me. The chef is creative. Let's just say this because, and so serving food by this chef is an act of creation. The experience itself is akin to art. But he has a problem with, not with gay people, but with gay relationships. Right? I mean, could be marriage or just relationships. Like the status of you being gay is not an issue for me. But when you start to take actions that are gay-ish, like being in a relationship with another man, then I don't want to associate my food with that because I don't want to endorse that. I don't want to feed you a meal. So you can come in if you're gay. And maybe you could come in with someone else if you're gay. But if you guys hold hands at any point and act gay, if you sort of like maybe sit too close together, or you whisper into each other's ears in a way that like two heterosexual guys would. I mean, doesn't that what this ruling basically say? I mean, putting aside the question as to whether I'm not discriminating against you because you happen to be gay. I'm discriminating because you do gay things.
Yes, I think that what you're saying is that the ruling essentially decouples status and conduct, and says that you can discriminate against a gay couple for doing gay things, just not for being gay, right? And that creates this kind of loophole in the law where the chef could come out and say, I'm not against gay people, but when gay men hold hands together in my restaurant, they're creating a message that I don't want to endorse, so I'm going to kick them out. And this was a huge debate in the same-sex sodomy case, Lawrence v. Texas in 2003.
I was about to say that, right? Like that's been how they've attacked gay people for years through the law. Sorry, Mark.
That was the entire argument. Was this law does not discriminate against gay people; it discriminates on the basis of homosexual activity. And if you read Justice Scalia's dissent in Lawrence, he adopts that line so fully that you might not even notice it. He exclusively refers to homosexual behavior. He does not talk about gay people. He talks about behavior. And so what I fear this decision is doing, and I'm not even sure Gorsuch intended this. I mean, this doesn't seem like a conscious thing. It's just he was sort of wielding his pen freely. And what he did in the process was really roll back this idea that was embedded in the court's decision in Lawrence that you can't decouple status and conduct, that being gay and homosexual behavior are sort of one and the same. And now he's rolled that back and said, well, there's a difference between discriminating against someone for being gay and doing gay things. And that could have really dire ramifications in the broader civil rights context.
And for trans people too, let's be real.
Yes.
This is going to go, you can be trans in your mind, but once you start to act trans or take trans actions that comport with your gender identity, then hey, discrimination is going to be allowed. That's the future.
Well, let me ask you about this. Also, religion is protected status. Same restaurant, same chef, right? Or, still involved in this artistic thing. But I'm a Catholic, a chef. Or maybe I'm a Catholic chef.
Yeah.
I believe that Jesus died for my sins and that any denial of Jesus is offensive to me. I'm okay with Jews coming in to my restaurant. But if they're wearing the little hat or they're wearing the strings, or I also saw a Jew can't come in and I was convinced he was saying a Jewish blessing over my food. Can I kick them out at that point? I mean, they're not, it just so happens they're Jewish. It's when they do Jewy things. That's when I have the problem. When they start to practice Jewy stuff.
You're asking the right question. So in the gay context, the line that Justice Ginsburg used in an opinion in 2010 was a tax on yarmulke is a tax on Jews, right? A tax on this thing that this group uses to exercise religion is a tax on the people who exercise that religion itself. And she and Justice Kennedy and some of these gay rights opinions extended that to the context of LGBTQ status. And now I guess it's being rolled back. But I think the answer to your question is this court creates whatever divisions it wants. And if it wants to distinguish between homosexuality and religious exercise, it'll just do it. It'll just ram through this sophistry because it favors religious freedom in its own sort of cramped interpretation over the freedom of LGBTQ people to access the marketplace. So I think those cases would turn out differently at this court simply because 5 or 6 justices think that religion should be protected and sexual orientation should not be protected.
Okay. All right. So fair enough. I'm a religious person and I take issue with the gay actions, right, in my restaurant. Not so much that they're gay. If they want to be gay, that's fine, but they can't be gay here. And you can't do any actions that exhibit gayness to me. I also happen to believe, as been in the Bible, and it's certainly we have a precedent in this country, that when black people and white people, like I'm okay with them being black and them being white, and they can be friends, but they're not supposed to mix romantically. And so I'm an artist, I'm a chef, we've stipulated that. It's okay for a black person and a white person to come into the restaurant at the same time. And they could even sit at the same table. But if I see them holding hands, or if they are married to each other, I don't want to endorse that. Can I now, since it's not a religious expression on their part, it's a religious expression on my part, can I now say, based upon that, like, that's just my religion says they're not supposed to mix. And so
I think the answer is maybe yes, and it would get to definitely yes if what the couple asked you to do was say create a cake for their wedding anniversary. They say, we are a black and white couple. We want you to create
that. I'm not
a
supporting
cake for a wedding
that
anniversary.
at all.
Under 303 Creative, I think it's very clear that you could say no to them, that you could say, I will not serve you a cake because that would require me to express support for your interracial marriage. And I will not do that. That violates my freedom of speech. There is no limiting principle in this decision that restricts it to LGBTQ people, nothing at all. And that actually surprised me. I thought what the court was going to do here was say, LGBTQ people are second-class citizens again. We're not allowing states to protect them the same way that they protect other classes of people. And the First Amendment just overrides all of these civil rights laws. But that's not what Gorsuch did. Gorsuch creates a total exception across the board, not just sexual orientation, but everything else, including presumably race and religion, whenever there's some kind of expressive conduct involved. So yeah, I do think if you take your example and you throw in any kind of custom creation, I don't know, a tasting menu that expresses the joy of our 10-year marriage, like that would fall under 303 Creative's First Amendment exception. And the chef could say, I'm not serving you tonight.
And then, okay, they say, well, what's the big deal? Go to the restaurant down the block. Well, but maybe there's only one nice restaurant in this town.
Right. And this is like the sort of stigmatic harm that Justice Sotomayor talks about that the majority completely ignores. The majority says, through Gorsuch, why would a gay couple even want this woman to make a website for them? If she's homophobic, there's a million other wedding websites. And he talks about how, like, when there is a monopoly on a business, it's different. But now that we have this free market, everyone can choose where to go. And Sotomayor says, I think correctly, like, does that mean it was fine in the Jim Crow South when Black people had a green book that they had to use to figure out which hotels they could stay at? Like, the harm is inflicted when the discrimination occurs. It doesn't matter that they could go to another place theoretically and get similar services. By being turned away and having the imprimatur of the law on that act of discrimination, you are telling people that they are not full and equal citizens under the law. And I think that's just obviously correct under the court's precedents, but I think this court is moving very far afield from the precedents that did create and protect the equal dignity of gay people.
All right, and I want to get to the affirmative action, and you're being a good sport hanging in here with us, but this is the end of your, close to the end of your season. And so, but one point, Sotomayor, and I think this actually, you cited this in your piece on this case. And this is important, I think, because this gets to so much of the sort of colloquial arguments about free speech in this, in our society on some level, where Sotomayor points out that nobody is in any way infringing on your right to express your opinion or to express yourself about, and nobody's forcing you to write anything different than you would do. The Colorado law says you could have a template, and you just need to let everybody use the template. But you're taking an extra action, and actions are not protected under like First Amendment law. Can you tease that out for us?
I mean, she says that this distinction would be absurd if it weren't so tragic. I think that there's no rational or consistent and principled way to distinguish between those things. And I think, like, the more important point that she makes, frankly, in that passage is that there are actually situations where people are having their speech suppressed or compelled on the basis of LGBTQ content. So she refers to the drag bans that are proliferating throughout the South. She talks about the don't say gay laws that are proliferating in red states across the country. And she says, those are the laws that are actually targeting expression as expression. all that this law does is target conduct. It says you have to sell your goods to these people regardless of their identity. This law doesn't target speech. It doesn't regulate any kind of expression. Those other laws do, but look at what this court chooses to pay attention to. Look at what this court views as an emergency that needs its relief, and look at what this court ignores, and that tells you what you need to know about this court's agenda. And that brings us back to an earlier observation we were discussing about how Sotomayor looks at the real world in her dissents. She talks about what's actually going on here. And I think this was a situation where she absolutely told it like it is and said, beware, because my colleagues are advancing the Republican agenda on LGBTQ issues and are going to selectively enforce what they view as freedom of speech in a way that does not benefit all people equally.
I mean, that seems like a slam dunk. You got 7 AGs going after Target now for having pride shirts. I mean, you can't come in as a customer and order a gay wedding cake, but because of the rights of commerce. But the rights of commerce will not even allow to sell to anybody a pride shirt. Right. That's the theory they're operating under.
Yep. And I mean, Target starts off that case, with an uphill battle, I think, because this court, and we'll see this, the trans healthcare case is going to go up to the court very soon, right? We'll see what the court says, but I can very easily imagine the court saying, well, children need to be protected against these images. And, we'll see, but I'm not super optimistic.
Okay, so let's move to the affirmative action case. I mean, we've touched on this a little bit. This was a case where North Carolina and Harvard, UNC, I think it was, and Harvard, both being sued. The cases were joined. And the question was, is it okay for colleges to include race as one of multiple factors? And when they determine they want to admit somebody into their school, they'll look at geography. They'll look at how wealthy the kids are. They'll look at whether they're a legacy student. They'll look at their extracurricular, their grades, and this and that. And one of them is race, because they want to create a diverse learning atmosphere on their campus. There's a lot of, I think, sort of evidence, but also that's what they want to do, that creates a better learning experience. Shot down. Give us the top line of what the argument was as to why they shot this down.
So the top line for the Chief Justice in his majority opinion is that these affirmative action programs flunk equal protection because they do not promote a compelling interest that is measurable, quantifiable, and judicially cognizable. So the schools argue that they have a compelling interest in promoting diversity in the classroom, which creates educational benefits. And Roberts comes in and says, well, they can't measure these benefits and prove that they are flowing from the affirmative action programs in question. And so we have no choice but to strike them down, which is an incredibly ironic way to end these cases, because the entire history of affirmative action at the Supreme Court has been the court saying that you are not allowed to measure race in any quantifiable way, that you are not allowed to measure the benefits of classroom diversity in a way that takes race explicitly into account, that you have to take a holistic view of race in the entire process, from the beginning of the applications all the way through to, seeing how the diverse student body improves the school. So for 50 years, the court has been saying you're not allowed to use race as a measurement. Then Roberts comes in this opinion and says, well, you're not measuring race, so we're not going to let you continue with these programs.
Why couldn't the defendants say, well, we know from, let's say, I think it was it in California? We know that minority enrollment in colleges drops after we're not allowed to take into consideration minority like a minority status in application.
So what Roberts says in response to that is, well, you haven't proved to us that having all of those minorities is even good. You haven't proved to us that having more underrepresented minorities in the classroom creates a benefit to students. And that is sort of end game for him. Like, if you don't show
what
us
about
evidence
benefit
of
to
that,
society? Is that
well,
no value?
So this is the problem, is that like 50 years ago, the Supreme Court said that this was the one legitimate, compelling interest that affirmative action could be used to promote, that it couldn't be used to right past wrongs, to redress history of discrimination, for the greater good of society, that the only thing it could be used for was to improve diversity in the classroom because that has benefits for students. And so, like, if that were the case, then you'd think that what colleges would like to do is say, okay, we'll have one class that has 10 Black students and one class that has 2 Black students, and measure how well other students do on their final papers, and see if like the presence of more diverse people made learning better in the classroom. But the Supreme Court said that's illegal. So the court has prohibited colleges from doing what they would need to do to prove that this interest is indeed compelling. And so it's just a classic catch-22. And I think the dissents point that out well, but Roberts just says, well, this is the position you're in and you flunked it, so affirmative action is over.
And we can't show, like, there's been plenty of studies that show having a diversity of perspective, it helps in terms of like solving problems. And I mean, the fundamental success of our country has been a function, theoretically, of a diversity of lived experiences, life experiences, and different perspectives that come from different cultures and backgrounds and races. Is that not, are they saying that you can't get from race? Race is not a proxy for diversity?
So 2 things. First, Roberts says in general that you can't assume that having diverse racial backgrounds will lead to diverse viewpoints, that it stereotypes people of color to assume that bringing more of them into a classroom will lead to more diverse viewpoints, because, you're just assuming that Black people have similar experiences that are different from white people's. But then he says, FYI, this analysis does not apply to the national security context, and military schools and these training academies, they are allowed to continue affirmative action because they present unique circumstances beyond this case, which, as Justice Jackson says in dissent, means you can have diversity in the bunker, but not the boardroom. So Roberts recognizes that diversity can be a good, but only when like nukes are involved, and in any other context, it appears to be bad for him.
Does he, okay, I was going to get to that. There are 2 exceptions that he says. There's 2 loopholes that he's carved out. One of them is that none of this applies to military schools and academies. Right. How does is he just saying that we need, like, you can't have a good fighting force unless you have like a mix of like white, Black, and Hispanic? I mean, is he literally saying that? Like, how does he justify it, or do you just like write it in the margins and go like, oh yeah, let's not talk about that?
Oh no, it's literally in the margins. It's literally in a footnote with no explanation. But I think you have to know some history.
I was joking.
So when the court heard the big affirmative action case, Grutter v. Bollinger in 2003, everyone thought that was going to be the end of affirmative action. And the pivot point was that the military came in with this brief, and like Gerald Ford was on it. It was a big deal. And all of these military leaders were like, we need diversity because it's important to a fighting force that's cohesive and that is ready for battle whenever, and that, can appreciate diverse backgrounds. And that really swung Sandra Day O'Connor in that case. There's a lot of evidence that shows that sort of moved the needle for her. And so I think Roberts wanted to head that off in this case. And the problem when the military comes in saying that is Supreme Court justices are happy to overrule college administrators. They're happy to overrule business leaders, the Forbes 500. They're happy to overrule all those folks. But when it comes to the guys in the uniforms with all of the medals, they do take a second before saying, you guys are full of shit. And so I think what Roberts wanted to do was say, okay, we're respecting the guys with the medals. When they say they need diversity, we'll let them have it. But everybody else, we think all of you are full of shit and none of you get to have the diversity that you want.
And just to be clear, I mean, I know I'm just repeating the obvious, but there's not illogic there. There doesn't even seem to be an attempt to deploy any logic. It's just sort of, again, just Deus ex machina. How do I make this ruling fit with the military? I just made it fit with the military.
Yeah, it's nice to be Chief Justice. You get to do whatever you want.
The other one is, and this one just strikes me as just absolutely nutso. You can, or incomprehensible. The other carve out is that a college can look at an individual's testimony, essentially, in the context of their essay, as to how race has affected them as an individual. But it has to be a tangible affectation of it, but it is. But how do you do that without the college administrator saying like, oh, they have this perspective because they're black or because they're white? Like, how does, like, I don't understand how that works.
Well, I mean, it'll require 1,000 lawsuits for us to figure it out. But I think what happened here is that Roberts is responding to Justice Jackson's hypothetical, both in oral arguments and in her opinion, where she says, does this mean that someone who is descended from slaves who were excluded from UNC cannot mention that history when he applies to UNC? Is he not allowed to say, as a black person and a descendant of slaves, I feel proud to be in a position to apply for this competitive school? And Roberts tries to write around that by saying it's okay for applicants to write about their race or ethnicities in an essay, but the college has to still judge them on the basis of their individual experience. So it has to be like about how their race played into their triumph in life or their struggles in life. Like everyone now has to write this kind of narrative of trauma, explaining how race affected their path to a college application. I think colleges are definitely going to try to use that to continue affirmative action in its current form. I think that white conservative lawyers are definitely going to sue colleges for doing so. And I think that as much as the court wanted to kind of just sweep away affirmative action and say, we're done with this, it's going to haunt us for years to come, because that sentence, that section in Roberts' opinion is like one page, and it just opens the door to so much confusion and litigation over the coming years and decades.
So are we going to have white conservative, maybe black conservative lawyers basically subpoenaing or asking for discovery? Like, I want to see all the essays.
Yes.
From all the kids here.
Absolutely. And
well, so can colleges like put in a like some type of thing like, this essay is your property, we will look at it and destroy it afterwards?
You know, I think Harvard should perhaps hire you as a consultant to think of creative solutions like this. This is the big mystery, like exactly how aggressive will these litigators be? When they went after Harvard and UNC, they had like top ranking officials at these schools sitting at the deposition table under oath. They had subpoenaed all of these documents and records about their behind the scenes conversations in the admissions room. Like there was no privilege there. There was almost no privilege. It all ended up out in public view. And so, yeah, I do think it's possible that you're going to see aggrieved white applicants represented by the same coterie of white conservative lawyers demanding access to these applications and essays, saying, show me proof that I wasn't good enough compared to this black person who got in. And like, maybe Harvard can try to make those confidential. I don't know. But if they do, they'll be sued. If they don't, they'll be sued. There's really no good way out of it if you're Harvard.
Can I also just say one thing about people who say like we should get rid of legacy enrollment and not affirmative action? Isn't the problem with legacy enrollment is that it has been built upon a structure where literally people were not allowed to get into colleges and universities because of their skin color? And so like, that's the issue, right? I mean, that's the issue, it seems to me, with legacy involvement, is that it's completely unfair. You're just giving people an advantage from birth that has nothing to do with who they are as a person or whatnot.
Right, of course. Because, you know, if UNC and Harvard only started letting in people of color in any real numbers like 50 years ago, that means that just statistically, the vast majority of people who will have lines and lines of families going back to the 1800s at Harvard or UNC, they're gonna be white by definition. So yes, legacy admissions basically functions as a big boost for white applicants across the board. That's why there's now a group trying to tackle it in at the Department of Education, filing a civil rights complaint. But that's going to take forever, and I think it's probably going to fail because it involves something called disparate impact theory of racial discrimination, which the conservatives don't like, which would require 5 more hours of conversation. But basically, when race is not explicitly considered, the conservatives don't think it's a problem. So I think they would probably rubber stamp legacy admissions as totally fine.
Right. I mean, so, if colleges want to find a way of making sure they have diversity, they have to come up with their own fancy proxy.
Yeah,
because that's what that's what legacy admissions is. It's a proxy for white people. I mean, just in terms of sheer numbers, that's just it. And they got to come up with their own proxy of like, I don't know what that would be, but Mark Joseph Stern, we will have you back after your long, well-deserved vacation. Hopefully,
this was your final boss
to tee up. To tee up the nightmare that will be happening a year from now when we talk about those cases. Because
the wheels
sure
are already in
motion.
motion.
Really appreciate you doing this, walking us through. It's very important. People need to be, aware of just like the implications of the courts, and we're about to feel them more and more. It's going to take a long time before this permeates out where people realize like, oh, this seems really effed up. Oh, that's because of, these Supreme Court justices who sit on this court. That's, I appreciate your help in that process.
Thanks, Sam. Thanks, Emma.
Thank you.
All right, folks. We went a little bit long, but like I say, very necessary. We are broadcasting live from the sauna. Tomorrow is going to be a disaster.
We're going to have to, I don't know what we're going to do.
You're going to bring in your little mini AC again?
I have it over there, but I read it was like this when it was really bad here. I got that little AC where you could put ice in it. And then I read online that actually sucks more moisture out of the air or something, or puts more moisture into the air and makes it hotter.
It dries your skin so that you lose like the cooling effect.
Yes. So the answer is no, but I'll probably come in like right before the show
There's going to be a little hum tomorrow in the it's going to be like the fans.
I think Wednesday is going to be even worse, honestly.
Yeah. I may be going collarless.
Whoa.
Fishnet. I'll tell you, we'll go into the fun half, but
you're going to wear fishnet?
Fishnet shirts.
Oh, nice. Yeah.
You don't remember those? Mesh?
Right.
I think I remember them.
I mean, what are you going to...
Why not?
Wear chaps too, or something like that.
Do you like neon colored fishnet top?
I got to. I'll show you guys the
Go to
picture.
Spencer's.
I forgot the. I got a package from. I believe it was Ronald Reagan.
Oh yeah.
And his idea of suns out, guns out has gone to suns out, buns out.
Okay.
Yeah.
Well, I don't know if that's the next phase we want to go.
Moving a little bit far from Mormonism there.
Yeah.
Yeah, a lot of problems in Vermont. Folks, just a reminder, it's your support that makes this show possible. You can become a member at jointhemajorityreport.com. Every time you do, we at least think that we're going to get closer to having a functioning AC in the office. Plus, you get the free show free of commercials, and you get all sorts of, well, not all sorts. You get some bonuses being a member in addition to access to the member show. You also get things like the ability to I am the show in the fun half of the program, and the sense that you're helping us survive and thrive. Join themajorityreport.com. Also, don't forget justcoffee.coop, fair trade coffee, tea, or chocolate. Use the coupon code majority, get 10% off. Emma.
Yes. ESPN, we're back. We're going to do some NBA, NHL free agency headlines. Obviously, the big story about Damian Lillard, too. The Pat Fitzgerald hazing scandal at Northwestern. That story is unfolding before our eyes. And we might touch on a little bit of the decline in sports media, the New York Times shuttling its sports coverage and essentially just outsourcing it to The Athletic, what this kind of consolidation means for sports media. YouTube.com/ESPN show today at 4 p.m.
Matt.
Patreon.com/Reckoning had a little movie showing for patrons, a documentary called Prairie Fire, which came out in 1977 about the 1915 to 1922 era of the Socialist Nonpartisan League, which was a bunch of socialist organizers that basically organized farmers to run in either primary, whichever could get power, and ended up being initially Republican and then later Democrat. And we look at a documentary from 1977 that has a lot of lessons, I think, for today. And yes, I was really pleased to be joined by film guy Matthew for that.
All right, folks. 646-257-3920. Let's see you in the fun half.
You are in for it.
All right, folks. 646-257-3920. See you in the fun half.
Are you ready?
Who sent us this?
Alpha males are back. Boy is back. And the alpha males are back.
Just as delicious as you could imagine.
The alpha males are back. Boy is back. And the alpha males are back.
Just wanna degrade the white man.
Alpha males are back.
I take all of it in my throat.
Alpha males are back.
Snowflake says what?
The alpha males are back.
You are a madman!
And the alpha males are back.
Oh no, Sam Seder! What a fucking nightmare!
Bring back DJ Danner.
Yeah, or a couple of them. Just put them in rotation.
DJ Danner.
Well, the problem with those is they're like 45 seconds long, so I don't know if they're enough of a break.
That's fucking nonsense. You see white people doing drugs, they look worse than normal white people, and all white people look disgusting.
And the alpha males...
Psych. Fuck them.
Snowflake says what? Snowflake says what?
A hell of a lot of bank. A hell of a lot of bank. A hell of a lot of bank. Okay, I'm making stupid money. Hell of a lot of bank. A hell of a lot of bank. All lives matter.
Have you tried doing an impression on a college campus?
I think that there's no reason why reasonable people across the divide can't all agree with this. Psych.
And the alpha males are back. And the Africans are black African. And the alpha males are black. And the Africans are back.
When you see Donald Trump out there, doesn't a little part of you think that America deserves to be taken over by jihadists? Keeping it 100. Can't knock the hustle. Come on, fuck them. Things I do for the bigger game plan. By the way, it's my birthday. Happy birthday to me, Jew boy.
I have a thought experiment for you.
And the alpha males are back. Africans are black. Alpha males are black. Africans are back.
Come on. Someone needs to pay the price for blasphemy around here.
I am a total pussy.
We are back. Sam Seder on the Majority Report. Lawful waffle. Days after Sam predicts Trump Kennedy ticket, it's seen on Roger Stone's Twitter. You never know who tunes into the show. I don't think that's. I don't think. I hope he's not getting advice.
I don't
from
think
us.
he's following up.
But I mean, one wonders. One wonders, like, I don't know what the value of that would be to come out with that during a Democratic primary. I mean, maybe there's a sense that I don't know. It's weird. but they must have some theory. But I'm sure it's a weird theory that they have going on there. We'll get to a couple of these. All right, let's get to the cluster bombs.
Okay, wait, hold on one second.
Because right now, Joe Biden is in, I don't know if he's right this moment in Lithuania for the NATO talks, but if he's not, he's en route. One of the big issues I think is going to be inclusion or the inviting of Sweden in. Turkey apparently has again put up a roadblock to this. And let me be clear. I mean, just because of how, I felt that NATO had NATO expansion was not helpful. Not necessarily that it was provocative for Russia, but it was just simply unnecessary to maintain a sort of like warlike footing. Putin did a very good job of convincing people who were NATO skeptical that there was value to the alliance, sadly. Sweden may get let in. Turkey seems to be basically trying to inhibit their inclusion so that they can get into the EU. Meanwhile, I would imagine another topic of discussion at the NATO summit will be the use of cluster bombs. And there's a whole, we'll go through all of the sort of like supposed qualifiers and mitigators because there's a lot of them that are being deployed. No pun intended. Here is Joe Biden on with Fareed Zakaria. This was on Friday, either just as the announcement that we were going to be sending cluster bombs to Ukraine was made. And to be clear, I don't know if Biden says it specifically here, but Russia has supposedly been using cluster bombs for an extended period of time. There are only, as far as I know, something like 10 countries that did not sign the international treaty, essentially disavowing the use of cluster bombs. Russia is one of those countries. The U.S. is another one of those countries. Turkey is one of those countries. Ukraine is one of those countries. There's a couple more. I can't remember off the top of my head. And the real problem with cluster bombs is that whenever you have wars, there's a certain amount of armaments that don't explode. And so they sit there.
They're called bombettes. So it's like a bomb and then little smaller bombs essentially get clustered, right? And they don't deploy. And they sometimes they don't blow up, I should say. But they sometimes remain dormant. And there are reports of children, particularly in Laos, which we cluster bombed the hell out of, maimed and murdered and killed years later after these bombs were dropped because they're just left there.
Horrible for the civilian population. Much harder to sort of like find those after the fact. But here's Biden defending sending those cluster bombs.
What made you change your mind and decide to give them these weapons?
Two things, Fareed, and it was a very difficult decision on my part. And by the way, I discussed this with our allies, discussed this with our friends up on the Hill. And we're in a situation where Ukraine continues to be brutally attacked.